has full power over asset forfeiture decisions because they're not prosecution decisions. In addition, when we wrote the legislation in Parliament dealing with racketeering, we also provided that the NDPP would be the person to authorize racketeering decisions. And I think there are some others as well, like centralization decisions and so on, that are not a decision, not the original decision to prosecute. So by legislation, several powers were given to the NDPP in respect of issues that do not relate directly to a prosecution. I mean, which relates to a prosecution, but isn't a prosecution decision, to be more clear.
So what you're saying is that in relation to asset forfeiture, the NDPP or acting NDPP, if there is one, would make such a decision to seize the assets of a suspected criminal.
Chair, in practice, there are a couple of hundred of those cases every year. So in practice, the NDPPs have authorized, for example, the head of the asset forfeiture unit to bring those applications. So it's not necessary.
Delegated authority. So you have delegated authority as the head of the AFU?
That's correct.
Yes. So let's confine ourselves to asset forfeiture. To your knowledge or in your experience, did Ms. Jiba, did she withdraw those delegations to you when you were the head of AFU?
No, she did not.
So you continued to authorize those seizures yourself?
That's correct.
Without any interference from her?
That's correct, yeah.
Okay. As far as the other centralizing decisions that you refer to your knowledge and to your recollection, were there any such decisions made or not made by Ms. Jiba?
Maybe you can be a little bit more specific, but if I recall correctly, there was a centralization decision made in the Boyson matter.
Was that a centralization issue, or was that an authorization issue under Section 2(4) of POCA?
I may have to refresh my memory. You're correct that there was a racketeering authorization done in terms of POCA. But if I recall, one of the odd things in the case was that the Director of Prosecutions in South Gauteng became involved in running the case. And I'm not sure how that came about. Because he obviously doesn't have jurisdiction in KwaZulu-Natal.
Yeah, I'm not going to ask you about that, and because you have no direct or personal knowledge of these matters, as I put to you earlier in the Boyson case. Now, given that, firstly, any case, whether it's corruption, fraud, murder, any crime or reported or suspected crime is initially investigated by the police. Yeah?
It's correct to, it's mainly correct, let me put it that way. Obviously in the days when the Directorate of Special Scorpions existed as well in the days when there were an investigating directorate as being set up. Now there is an investigating DPP that authorized those investigations, and the methodology was very much that prosecutors are involved in the investigation from inception, basically. So they would be part of seeking the authorization from the NDPP.
Are you, to your knowledge, or are you aware of any request by any special prosecutors to prosecute, especially corruption, was referred to Ms. Jiba and was authorized or declined?
Sorry, I'm not quite sure I understand. Authorized in what sense? Or
In the sense you were explaining that it is largely correct that investigations would be initiated by the police, but you explained a la Scorpions or a project team similar to that, where there'd be a special prosecutor who would also be able to seek authorization to pursue the investigation of a particular matter, especially high priority crimes. But then that prosecutor would have to seek authorization from the NDPP or the acting NDPP. Do I summarize it fairly?
I'm not quite sure I completely follow you, but let me put it that way. In terms of centralization and racketeering authorizations, obviously the NDPP must authorize. In terms of high-profile cases, most NDPPs have had a policy or a request that they should be briefed on those cases so that they know what is going on before they read about it in the newspaper. So that's just a briefing to the NDPP, and usually the deputy nationals would sit in on such a briefing. It's not about whether there should be a prosecution or not. It's simply about to make sure that the NDPP doesn't hear about it on the radio one morning when it's a sort of big earth-shattering case.
So the NDPP and the acting NDPP, if there's one, bears no direct knowledge of an investigation or an ongoing investigation, save where that NDPP or ANDPP is approached for authorization, either where there's a high priority crime or alternatively in a racketeering case where his or her authorization is required under POCA. And according to your evidence also, the NDPP would, I suppose, on a regular basis also seek to be briefed, especially on high-profile matters, so that him or her can at least be brought up to speed instead of reading it in the media or hearing about it in the media.
Indeed. I think mainly what would happen in those cases is that it is the Director of Public Prosecutions in the province, or in the case where there may be special directors or investigating directors, I think they would be the ones that would bring it to the attention of the NDPP. Depending on the NDPP, they would say they would like to be briefed in some detail, or they may just want a report so that they're aware of the case. So there's not sort of I can't say there's been a uniform policy that all NDPPs applied in the same way. But I think generally it is understood by the DPPs, if they have a case that's going to hit the headlines in their province, that the NDPP should be alerted to that case and would then indicate whether they want a more formal briefing or not.
Now, so would it be fair to summarize your evidence that the NDPP or acting NDPP himself or herself has no direct involvement in a case, and certainly does not initiate any investigations that may or may not lead to prosecutions.
I think that's broadly correct. I don't think all NDPPs operated on that basis, but that is what the situation should be. I think some NDPPs believe that they did have the power to institute a prosecution, but I think that's a bit in the past now.
Yes, we know that you were involved in such a case. But what I want to ask you is your sweeping allegation about Ms. Jiba, or certainly aimed at Ms. Jiba, that in recent years there's been no investigation, let alone successful prosecution of any cases involving corruption. Is my recollection of the evidence correct?
I was, I think, a bit more specific, and that is to say that there was a list of serious corruption cases that the anti-corruption task team was dealing with in 2012. That's the latest list I've had access to. And as far as I've been able to ascertain in the NPA, and I have asked this question in formal meetings, and nobody has so far contradicted me, none of those cases has actually gone to court.
Can you remember? Can you remember offhand which cases you are? Can you be more specific?
As I say, it's about 80 cases, so it's difficult to be more specific, but I'm happy to provide the list to you and to the inquiry.
And can you provide us also with the minutes of these meetings where you raised this in the meetings?
I can do so if the minutes are available.
And can you tell us whether Ms. Jiba presided over some of these meetings that you referred to, and in respect of which we're going to look at the minutes?
It's fairly recently, so I might just check if those meetings took place at the time when she was there or not. I'll revert to you on that.
Well, as you know, she was appointed in December 2011. Yeah?
That's correct.
And yeah, she was appointed in 2011. And then I think Mr. Kasana was then appointed, I forget the exact date now, but was it in 2013?
I think October 2013.
2013. So can you be more specific? Because when it comes to Ms. Jiba, so we want those minutes in the period when Ms. Jiba was presiding over the NPA as its National Director of Public Prosecutions, where corruption cases, high-profile corruption cases, were not pursued by the NPA.
I will do my best on that one.
So do you want to still persist in your view that under her watch, corruption cases were not pursued at all or enjoyed a low profile? Or do you want to reserve your judgment until we have the statistics and the minutes of these meetings before the inquiry?
I think to be accurate, it would be best to go for the second option. But what is
Yes, sometimes we
undisputed
become
is
a
that
bit-
in recent years she was back at the NPA for a significant period. So it's not, when one would expect somebody in her position to, given the situations we have been in, to be very proactive in terms of finding out what's happening about corruption cases. Which ones are on the go, which ones are not happening.
And you say you've been proactive in that regard by raising them in meetings.
That's correct. But not in a meeting where she was present.
Your evidence is that these would be, but we would have minutes of these meetings. You're going to produce them.
I will do so. I haven't seen the minutes yet, so I'm not sure if the issue is captured in the minutes, but there were plenty of people in the meeting who can corroborate what I asked.
But would you accept that this is an important enough topic to be captured in those minutes?
I would submit so, yeah. But I don't know if they were captured in the minutes at this stage.
How does it work in the NPA? Surely you get a copy of the draft minute if you
Mr. Arendse, we will not finish.
Yeah.
We will not finish.
You have asked Mr. Hofmeyer to produce a list of cases. You have asked him to produce the minutes of those meetings. You have asked him if he would want us to reserve those questions regarding those until he has produced the information that you require. And he has responded to say he would prefer that option because it is a better option. Can we just proceed along those lines?
Madam Chair, I would gladly do so, except that we sit with a witness who in advance already of either not locating any minutes or locating minutes where these matters are not recorded, is already saying he's not sure if they were captured. I'm perfectly entitled to ask him, so what is the process of minute taking at this important institution in our democracy? If you were in a meeting, then you would expect a draft minute. It is circulated. It happens in organization, even in a cricket or a soccer club, so that the decisions are correctly recorded. So I'm asking him, what is the process of minute taking in the NPA?
But didn't he
And,
say...
and it's not a question that I'm asking.
Him to produce the minutes and the list. He has undertaken to do so. And you've also asked him if you can reserve the questions in regard therewith for the time that we get the list and the minutes. And he says yes, he would prefer that because that's a better option. Shouldn't we proceed along those lines? And
Madam
then
Chair, we can
if those
proceed
minutes
along
and
those
those
lines.
and the list...
No. Save and accept that I don't want us, least of all the panel, to sit in a situation where either no minutes are produced or minutes are produced that does not contain any reference to the issues about corruption cases raised by Mr. Hoffman, and we are then told, oh, sorry, actually I did raise it, but it's not recorded in a minute.
But shouldn't we wait until we get those minutes?
Then it's a complete waste of time.
But we cannot question him on minutes that are not before us, and we presume that the issues are not captured or they are captured. We haven't seen the minutes. You've asked for the minutes. Why don't we wait until we get the minutes?
Yes, Madam Chair, but the witness has already foreshadowed any possibility that it may not be in the minute. That is why I've asked him what followed in when it comes to minute taking and recording of decisions at the NPA. But if you wish me to continue, I'll do so, ma'am.
Mr. Arendse, I would imagine, now that you say he has foreshadowed that, if there is no minute or if it's not properly recorded, as would have been the case, you are entitled, fully entitled, to then raise that issue and ask us to draw whatever inference you want us to draw. But to then take about half an hour talking about minutes that are not here is surely a waste of time.
No.
And I say that in the, and I'm sorry, we're saying that in the context of the time that we have.
And you will certainly get your opportunity to question him about those minutes at the time when we have the minutes before us.
My question is not about the content of the minute. My question relates to the process of minute taking at the NPA and how these minutes become final minutes that one can rely on when in a process like this.
Should you not reserve that question at the time when we have the minutes? Then it can be questioning around the minutes.
Yes, we'll get them at the time only for Mr. Hofmeyer to make up another story about the minutes.
Can you please proceed with your questioning? We'll follow the questioning around the minutes when we have the minutes.
Madam Chair, I strongly object to that statement by Mr. Arendse. There's no grounds for that. It's insulting and it's uncalled for.
Mr. Arendse, will you kindly move on?
I will proceed. I have asked the question. Mr. Hofmeyer has not offered me an answer, and we leave it there. We'll see what the minute produces. He has also said, I think only after I put it to him, that he will now reserve his judgment also in relation to his sweeping statement that Ms. Jiba was party to some of these decisions not to pursue corruption cases. Because he had earlier made a sweeping allegation that she is.
Mr. Arendse, can you kindly move on?
Just an issue that was raised with me during the luncheon period for you, Mr. Hofmeyer, and for the panel, because my vision is limited to seeing you on the screen. I can't see what's happening on either side of me or behind me. Are you, during your cross-examination, discussing the evidence or taking advice from your counsel or interacting with the evidence leaders in relation to the evidence that you are giving? Because that has been observed by my team, and we need to know whether that's the case or not. If it's not, then it's no problem.
Madam Chair, maybe I should come in here. During the lunch adjournment, I did have a conversation with Mr. Hofmeyer. I then walked over, I had a conversation with Advocate Rip. I then walked inside, I had a conversation with Advocate Masuku. And the conversation I had related to the logistics on the way forward and my indication to Mr. Hofmeyer about whether they were available and giving evidence. If the team had anything to ask me about it, then they could very well have asked me besides making an inference about my behavior. And now this is the second accusation of some sort of bias being made, and it's untenable.
Mr. Hofmeyer, Mr. Arendse, we have gone this route earlier, on Friday, I think. You have made allegations against the evidence team, and you've made them in this forum. In other words, those allegations of bias in particular, are now part of a public record. The lead evidence leader responded to your allegations, making it quite clear that, amongst others, the evidence that is led in this forum is evidence that is provided to counsel all the time. And they also made the point that to be accused of bias on their part is totally unfair. The fact that witnesses are not readily available is a challenge that we all face. And every time when a witness has to come, that is discussed between the two teams as colleagues, with all the collegiality that it deserves. It is for that reason that the evidence leaders put all the evidence and affidavits that will come before this forum in evidence is put in a Dropbox. And it is the openness with which they want to deal with evidence that comes before this forum. The discussions that you have as colleagues is part of a basic principle. The openness and discussions is part of the basic principle in the way this inquiry will be dealt with. And they took exception to the allegations that you made, responding as they did. And we had expected as a panel that you will finally respond and hopefully withdraw the allegation. And it is true that you're making this allegation for the second time. Now, we know that as colleagues, you would probably have discussed this somewhere where only the two teams would be in each other's presence. But because you made these allegations in this forum, on a public platform, we as a panel expect that you will hopefully withdraw those allegations based on the responses of the evidence leaders in public, and therefore it become part of the record. What is your response?
Madam Chair, can I just assist?
No,
with that?
before
Madam
you
Chair,
respond,
sorry.
before you respond, your colleague, Mr. Masuku, wants to say something.
The note I sent to Mr. Rense related to the evidence that Mr. Hofmeyer had given, which was that he was going to seek he was already compiling a list of cases that had not been prosecuted or on which decisions had not been made. And yet was doing that at the instance of the evidence leaders. And I raised with him and I said, but how can Mr. Hofmeyer be compiling such information at the prompting of the evidence leaders? Because it suggests that during cross-examination, they're having conversation about what information should further be provided to the panel, and that would be wrong if that were taking place. So Mr. Rense is raising a pertinent point which relates to how the witness, the evidence of the witness himself, that he is in fact being prompted to provide further documents while he's under cross-examination. And we're asking ourselves, why was this information not provided for the evidence to be laid in chief? Why is it being provided during cross-examination? That is the context in which it was raised.
Okay, thank you.
With respect,
Before you respond, Ms. Bauer, Ms. Moroka wants to ask a question.
Did you then approach the evidence leader to find out what the position is and tell her that if it were so, it would be untenable, instead of opening it up for this long
No, I did
emotive
not. I
debates.
am under leadership. My lead, the first person I conveyed my concerns to is my leader. If then my leader will provide leadership on it, and that's what I did.
And he didn't provide direction
No, he has provided direction
to
because
you.
he has. No,
Because he's answering it, he's addressing it in this forum.
no, and he's correct with respect. He's correct to address it to this forum, and this forum must understand that if a witness says, "I have been prompted to give further evidence, further documents while I'm under cross-examination," if that's what the witness actually gives the impression of saying, that must actually come on record. It should not be something that is spoken on the side. And I think my leader is absolutely correct to have raised it openly in the forum.
Ms. Power?
The reference to the list of 80 cases was made before my conversation with Advocate Hofmeyr during lunch. So I don't understand that in the first place. Secondly,
The assertion is that Mr. Hofmeyr informed them that on your prompting, he's going to do that. So the question would be for me, for instance, is at what stage did the prompting come? And that is why I say it would have been better if you had been approached to say, is this what happened? Because now we must ask from you, when did this prompting come?
Because we are under the impression that or at least I'm under the impression that Mr. Hofmeyr offered to provide this list of cases in response to a question that Mr. Arendse asked. That's the impression that I had.
Yes, but in doing so, what he did say was that he was already he was already having that list. He had already was in the process of putting that info. We can run we can rewind the evidence. The impression I got, and I think I wrote it down. The impression that he gave me was that he had already triggered that process of obtaining that information from the NPA, and said at the request of the evidence leaders.
Yeah.
And so that's why I got concerned that may well have been taking place.
Yeah, it is
And
true.
we're not blaming the evidence
it
leaders.
is true. It is true. I also heard him say he has already asked for a list from the NPA. But my impression was that the list comes up in response to a question. And then he said, I could do it quicker because I've already asked for a list. So your submission is that a request for a list was prompted by the evidence leaders.
No, that's what Mr. Hofmeyr said.
No, not during cross.
No, he did say that. That's why I said we can rewind the record, because that's what I had.
Yeah.
I heard him say that he had
already
already done so, and he did, and he pointed at the evidence leader and said, I'm already doing so because I've been asked by the evidence leaders.
No, I
we
didn't
can
hear
run
him
it.
say. I didn't hear him say he was asked by the evidence leaders. I heard him say he's already asked for a list, and my impression was a list from the NPA. I didn't hear him say we can run the record, but I didn't hear him say asked by the evidence leaders to get the list.
I understand that is a significant concern to the panel, and we mean no disrespect to the evidence leaders, and I apologize personally if the impression given is that we think they are biased. They are not. They've conducted themselves with absolute integrity, and when I raised it with my leader, it was in the context of my understanding of what the evidence was. So it's appropriate. If their objection is that he didn't say so, that's a different objection to saying that we are alleging unethical conduct. It's not unethical conduct. If it's happening, then it must stop.
Can I maybe make it very clear? I at no stage during Advocate Hofmeyr's cross-examination had any conversation with him about producing a list. I am aware that there are corruption cases that have been reported to Parliament, and I have sought to seek that weeks ago. It had not been forthcoming. Weeks ago, I had a conversation with Mr. Hofmeyr and knew about the list. I could not find that evidence, and it hasn't formed in any way of what we've done. So if Mr. Hofmeyr is in the process of compiling a list, it had nothing to do with anything that I had asked him during cross-examination. Or during lead, the conversation of a list emanates from a report to a portfolio subcommittee, which I actually think is on the record, and which there is a reference made about the prosecution of corruption cases. And there isn't anything that emanates from that. And I have asked about 12 people about it, including, if my memory serves me correctly, I'm actually not sure, but I may very well have asked Mr. Hofmeyer. But let me be very explicit about this. Neither during direct nor cross-examination have I had a conversation with Mr. Hofmeyer about this list that he mentioned today.
Do you accept that?
We do accept that it is what it is.
Can I find out, because this really perturbs me. The allegation from Mr. Arendse is that during the lunch adjournment, Mr. Hofmeyer was having discussions with the evidence leaders.
No.
No, I'm saying I don't know whether you didn't hear him.
No, what is, he didn't say that.
What did he say?
He was talking about a conversation that we were having as a team. We were having amongst ourselves during lunchtime. That's where I raised this issue that I believe I heard Mr. Hofmeyer say.
Yes, yeah.
And that is asking that question in that context. That is why he's saying to Mr. Hofmeyer, are you discussing evidence? It's based on that.
Then I apologize. My understanding was that because he's not here, that's how he started the introduction was, because I'm not here, I don't see what's happening between the parties. I heard that. Because I can't see what's happening, the parties, the evidence leader and Mr. Hofmeyer are talking. And that's how she then responded and said, I talked to him, I talked to the other parties.
Can I say?
Sorry, Chair. And if I'm wrong, Mr. Arendse must say I'm wrong.
Yeah. Can I say, confirm if I'm right? Mr. Arendse's statement that Ms. Moroka is referring to was based on the understanding that he got from you, Mr. Masuku, that Mr. Hofmeyer indicated that the list that he said he has already asked was prompted by the evidence leaders to ask. Nee. And that is why he reacted or responded like that.
That is correct, Madam
Yeah.
Chair.
And now you have accepted that, although he says he has a list, and you and I heard him say, at least our impression that he said it, he has already asked for a list, but you accept that the list that he has already asked for has not been initiated by the evidence leaders.
What I seem to hear from
what they
the evidence
say,
leader
yeah.
is that, in fact, she has asked for that information, but she says that she hasn't asked for that information during when she was leading evidence or in cross-examination, and I accept that.
No.
But that information is, in fact, information that she has asked, not just according to her, not just Hofmeyer, but other people who may well have that information with them. So, Madam Chair, it's really, I apologize that this thing is trapped us where we are now. I accept that the evidence leaders feel that they are being attacked. It's not the intention. All that we were trying to do is to raise something that we thought was of value in as far as the integrity of the process is concerned, because if that was the evidence, we would have wanted that to be if they were in fact approaching or speaking to the witness during cross, we would have wanted that to be brought to your attention. And if we are wrong on that, we unreservedly apologize for it. And we certainly, I can't say, speaking for my leader, we apologize and we would withdraw it.
No, I think your leader has heard you. Okay. It would concern us if it was otherwise. So I think we can proceed. Mr. Arendse?
Madam Chair, can I speak for myself?
You've heard.
He wants to speak for himself.
But you have heard.
Can
you
I
have
speak
heard,
for myself?
Yeah, but have you heard what the discussions have been? You've heard the discussions.
I've heard the discussion, and I want to go back to what I said, and I owe no one an apology. I said that I cannot see other than what is in front of me on the screen. And then I said, it has been observed. I made an observation that required an answer. The observation was that Mr. Hofmeyer has been seen by my colleagues to be interacting with various people, including the evidence leaders. And I hope that it is not in relation to his cross-examination. Ms. Bauer has given an answer which I am not in a position to argue with or to controvert, and I accept it. But I certainly don't have any grounds for making an apology, because I did not accuse her. If she did speak to him about a matter that arises in cross-examination, then obviously that was wrong and she must explain it. But she said no, it was unrelated, it was about dates or whatever she spoke to them about. But it is a concern that was raised with me by my client and my team, which I rightly raised in this forum. It seems now to have been dealt with. There is much to do about nothing, and I'm quite prepared to move on.
Thank you. And I would like you to move on. But we will note
Thank you, Madam Chair. I'm sorry.
You are not willing to apologize for something that you say you can't apologize for. But move on, kindly.
Yes, because I didn't accuse Mr. Hofmeyer or Ms. Bauer about anything. I raised an observation and they've given an answer, which I can't contest.
Can you move on, please, Mr. Arendse?
Thank you. Thank you, Madam Chair. Mr. Hofmeyer, you were obviously involved in the spy tapes case, but of course we know that itself has a long history and has been the subject of several court cases. But did you play any role in the NPA's decision relating to the tapes themselves and the transcript of the tapes?
I'm not quite sure I understand the question.
The question is whether you played a role in the discovery of the tapes or the transcript of the tapes in the spy tape saga, because that involved many court cases.
When we were initially taking representations from Mr. Zuma's legal team, they indicated that they had some recordings about what was being said on the telephone. So there was a meeting in the NPA where I and I think one or two other colleagues sat with them, and they played the recordings to us. After that, we had decided that we did not want to rely on recordings obtained where we don't know the origin, we don't know who made the recordings. So there was a decision made that we would go to the State Security Agency, because we had heard in the context of the Browse Mole investigation, or we had gained information in the past, that the telephone numbers of the telephones of Mr. McCarthy and Mr. Nguka was intercepted during the Browse Mole investigations. So the recordings that we used was the recordings that had been that was on the records of the State Security Agency. We then obtained copies of those recordings. We tried to transcribe at least the relevant bits of it. But yeah, that was the process around the recordings.
I think, excuse me if I perhaps wasn't quite clear what I'm asking about. I'm asking specifically about the application brought by the DA to set aside the decision not to discontinue the prosecution of Mr. Zuma, and you will know that pursuant to that application, or part of that application, there was a request for the tapes and or the transcript of the tapes. I'm asking about your role in that.
I'm just not quite sure what particular role you're talking about. If you can be a bit more specific.
Okay. Can we start at the beginning? You know about the DA application launched in the Gauteng High Court in Pretoria against the acting NDPP at the time, Share, to review and set aside his decision to discontinue the prosecution of Mr. Zuma. You know about that because you were intimately involved in that decision, as we discussed earlier this morning.
That's correct.
Now, during the course of that decision, and you know this as someone, as you said, has been involved in many, many court cases, hundreds, I think you said, there was also the request for the usual Rule 53 record. In other words, the information on which the decision was based or relates to, whatever is relevant to that decision, and clearly the tapes and the transcript of these tapes were relevant to that decision, and that was then demanded by the DA. Do you recall that?
I do.
So, in the course of considering the DA's application for the tapes and the transcripts, were you involved at that level in deciding whether or not to make it available, or whether you should only make it partial, or whether you should argue that it shouldn't be available at all because of privilege or confidentiality or whatever? Were you involved in those discussions?
I was.
And do you you were involved? So you were together with Ms. Jiva in those discussions?
Yes, I was.
So are you in a position to comment on Ms. Jiva's conduct during those discussions?
It's some time ago, but I can't say that my memory is 100% accurate on it. But as far as I remember, she did assist in obtaining access to the State Security Agency for us to get copies of the recordings that they had. I think we had suspected that the recordings that were given to us had come from crime intelligence, and we were not sure if it was lawfully obtained or otherwise. So we were keen to, if we were going to consider the recordings, that we wanted to have something that was lawfully done and where there's proper records of it. So my memory is that she assisted us to get access to the State Security Agency recording.
And would it be correct that you had prepared the transcript of the tapes, having listened to them at your offices? You listened to them, I recall you said, if I'm wrong, just correct me please, at the offices of the NIA, you listened to the tapes?
Yes, and eventually they gave us a copy of the relevant conversations, which I, together with some of my colleagues, then transcribed. Or at least transcribed the relevant bits. We didn't try and transcribe everything.
And according to your recollection, Ms. Jiba participated in these discussions and was agreeable to whatever was decided on how to deal with both the tapes and the transcripts.
Sorry, I don't quite understand the last part of your question.
I assume, Mr. Hofmeyer, that you decided what to do, what to prepare, what to disclose, what not to disclose. You were part of a team, and you've confirmed that Ms. Jiba was also part of that team. Right?
I was part, we reported to her at that time.
Okay, put another way, in a negative way, which I didn't want to ask you about. But did she do anything to obstruct, or did she do anything to frustrate or to subvert this process which you were now party to, that you were involved in, securing the tapes, securing the transcripts, deciding whether or not to make it available?
As I've already said, she did assist us with getting access to the tapes. And she didn't do anything wrong or bad about that. She assisted us with that.
And at the time, the counsel involved was Mr. Kennedy, is it?
That's correct.
Paul Kennedy. Yeah. And do you recall that there was a debate on whether or not the recordings and the transcripts should be excluded on the basis of confidentiality?
I do remember the debate, not much of the content, but I do remember the debate.
And you remember the matter came before Matopo J in the High Court?
Yes.
And you remember that there was some criticism of Ms. Jiba, who was then the acting DPP, by Matopo J. Can you remember what the content of that criticism was?
Chair, I would have to refresh my memory on that.
Do you recall that your team, your group, as you discussed how to deal with the transcript and the recordings, actually took a view not to have a view? Because the view was that this is a dispute between the DA and former President Zuma's legal team.
Sorry, Mr. Arendse, did I understand you? They decided to take a view, not to take a view.
Yes.
Okay.
In other words, the NPA took a stance to be neutral in that what they regarded as a dispute between the DA and President Zuma's legal team. In fact, you then took a decision to abide the decision of the court.
Again, I would have to refresh my I do remember the issue. Who said what in the debate, I would have to refresh my memory about.
Now, can I read back to you what Mr. Justice Matopo said when he criticized the stance of neutrality? And before I read that, I take it that you don't have an issue that you were party to this neutral stance to be adopted by the NPA.
My recollection is that I was in favor of supplying the recordings to the other party in the litigation. But let me go and verify that from our records.
Now, let me read to you. I will come to that. Judge Matopo said, finally, on this point, I need to say something about the conduct of the first respondent, the acting NDPP, and that's Ms. Jiba, with regard to the transcript. Counsel for the first respondent, quite surprisingly, submitted that the first respondent, quote unquote, holds no view, unquote, with respect to the transcripts and does not join issue with the applicant and third respondent and will abide the decision of the court. The stance adopted by the first respondent is irresponsible if regard is had to the fact that it was one of the parties to the proceedings in the High Court and SCA. In terms of the SCA order, it is obliged to file the record. Adopting a neutral position is akin to abdicating its duties and responsibilities. It most certainly misconceived its position. Now, as part of this group that you've confirmed you were party to, do you share those criticisms that you abdicated your responsibilities and should have adopted a firm view on the tape recordings? Or do you again avoid that responsibility and say, no. I was part of a group, but actually I wanted these transcripts and recordings to be produced?
My memory of the time was that I was in favor of releasing the transcripts, that there was no point in keeping it away from the DA. But as I said, it's a long time ago, so I would just like to go and check my records on that.
Now there is there's a memorandum which had been submitted by Advocate Paul Kennedy that is in the Dropbox, and perhaps the evidence leaders can help me find it, because I don't have it in front of me, but it's on the Dropbox.
It's folder M number 23.
Thank you, Ms. Bauer. This is what Advocate Kennedy says. What appears relevant for present purposes, and he's referring to the allegations against Ms. Jiba in this inquiry, is to make clear that the stance of neutrality was not a frolic of her own. It was a position adopted by her as client and us as a team collectively. We furnished our legal advice to her and her colleagues for the reasons already summarized. She was, in any event, as I recall, not keen to adopt any definite stance on the issue of production of the disputed materials. But when that approach was suggested to her by us as counsel, being prudent, cautious, and sustainable, she accepted the advice and gave us instructions to act accordingly. We proceeded to act in accordance with that position. So now that unless of course you dispute Advocate Kennedy's recollection, but do you accept that you were party to that decision as part of the collective?
I recall the memo now that you mention it, and I confirm that that was Kennedy's advice. My own view, though, as I have said, was that really there was no point in withholding this.
So you also recall, but your view is not recorded by Mr. Kennedy in his memo, and it's not something that you felt strongly or so strongly about that you would say, look, either I'm going to withdraw from this group or I want to have nothing further to do with this issue. You continued being part of this group.
Yeah, I did not. I mean, my own view was that we were going to be forced to disclose it anyway, so we were simply delaying things unnecessarily, but I didn't withdraw from my participation in the case.
You will also recall that because there was an application for contempt brought against Ms. Jiba, the acting NDPP, and you will recall that that application for contempt of court was dismissed by Matopo J. Do you recall that?
Sorry, in broad strokes, yeah.
So that judgment was then taken on appeal, and you will recall that one of the grounds of criticism against Ms. Jiba that forms the subject of this inquiry, and that also formed the subject of the GCB application for the striking off of Ms. Jiba, was the judgment that was then taken on appeal. Do you recall that?
Again, in broad strokes, I can't remember what the judgment said, I mean, in detail, but I would agree with both the broad strokes.
Let me read to you, and it's in the memo at paragraph 41, NAFSA JA, as it then was expressed, the following criticism of the position that Advocate Jiba adopted. And I quote, in the present case, the then ANDPP Ms. Jiba provided an opposing affidavit in generalized hearsay and almost meaningless terms. Affidavits from people who had first-hand knowledge of the facts were conspicuously absent. Furthermore, it is to be decried that an important constitutional institution such as the Office of the NDPP is loath to take an independent view about confidentiality or otherwise of documents and other materials within its possession, particularly in the face of an order of this court. Its lack of interest in being of assistance to either the High Court or this court is baffling. It is equally lamentable that the Office of the NDPP took no steps before the commencement of litigation in the present case to place the legal representatives of Mr. Zuma on terms in a manner that would have ensured either a definitive response by the latter or a decision by the NPA on the release of the documents and materials sought by the DA. This conduct is not worthy of the office of the NDPP. Such conduct undermines the esteem which the office of the NDP ought to be held by the citizenry of this country. Do you now recall that criticism?
I do.
What was your response or reaction to such criticism, especially when some of our NGOs who are described from time to time as the watchdogs of our constitution, and the GCB, who then subsequently brought an application for the striking off of Ms. Jiba, amongst other things because of what was said in this judgment? What was your response or reaction to it?
As I said, I'm finding it a bit difficult to recall all the details, but I was generally in favor of releasing the recordings to the other side. So in that sense, I felt that the judgment was correct, and it was unfortunate that we had to go there.
Mr. Hoffmeyer, just before we go on with this memory, but there are some matters that you've got a good memory on. For example, there's the Celebi incident, which I think goes back to 2007, the arrest of Gerry Nel. So those are things that go, this matter goes back a few years. Now, in this matter, you were involved in this group. You were part of a collective. You come from a political tradition where it is the collective that is important and your own personal views that are subsumed in the name of the collective. I don't have to remind you or give you a lecture on that. You agree with that?
I would like to think that even if in my days in the UDF, the trade union movement, the ANC, I seldom was swayed by the views of the collective. I made up my own mind, I took my own decisions. So I'm not quite sure what you were trying to get at about the views of the collective. In the NPA, when we had meetings, there was sometimes agreement, there was sometimes disagreement. But the nature of the beast in the NPA is it's not the UDF or the ANC. That there is a boss who has the final say in things. So you can seek to influence the decision, but in a sense, you know, you can give your input, your views, but you don't have the power to make the decision or to instruct your boss to make a certain decision. You can try to persuade. So I don't think the analogy with the sort of democratic movement is a good analogy.
Okay, let's leave that analogy. I thought that would be part of your political pedigree, but it appears not. Let's talk about an institution like the NPA, because you said one of the things that you lamented was, you know, the meetings that we used to hold, this collective where we discuss things, that seemed to have gone out of the window in recent years. And you almost equated that with the decline of the NPA. Do I fairly capture the essence of your criticism in recent years of the NPA?
I think my experience has been that when the NDPP does not take his or her 4 deputies into their confidence and make them part of discussions on big serious issues, that there usually is something that one wants to hide. Because there's no reason, I mean, all prosecutions end up in court. It's not secrets that we are discussing. So, you know, when I am excluded from certain decisions, when I'm usually included, then it makes me somewhat suspicious.
Now, Mr. Hoffmeyer.
But I don't have an expectation. I know I work in the state, I have a boss. And it's up to the boss to decide how much advice, how much collective decision making they want to be involved in. So I'm not complaining sorry.
Mr. Hoffmeyer, we're talking about a very, very serious matter in relation to which you were a party. You actively were involved in a group of very senior NPA officials, including the then acting national director, and that came to a decision. You seem to persist in your view that yes, there was such a decision, but you don't want to take responsibility for that decision because you said you had an opposite view that the tapes and the transcript should be released.
All I'm indicating is that I know it's not my decision. I can participate in the decision-making process and I can give my views. So I can't be aggrieved when the NDPP makes a certain decision, as is his or her right. But I don't have to be happy with the decision simply because it has been made.
This is a bit confusing, Mr. Hofmeyer, if I may, Mr. Arendse. You made a point that you were part of a collective decision, but you also mentioned that if you are excluded from decision making, there's nothing that you can do. Were you excluded or were you included in decision making? Or which decisions are you talking about?
It depends on the time period, Chair. I think at that time
These were at very
yeah. At that time we mainly made collective decisions. But ultimately the decision is that of the NDPP. To the extent that the NDPP accepts or doesn't accept your view, it's the NDPP's decision. So you can have input, you can put your views, but it doesn't mean that it's your decision in the end because you may have disagreed with the decision.
So that's what you mean by exclusion? Oh, okay.
No,
by
sorry,
being excluded.
No,
if the NDPP makes a decision after you have made a collective decision, maybe recommending a particular decision to her or him, if she or he makes her own decision, you accept that it is her decision to make.
Yeah, and so I think, you know, ideally one wants to have input in a decision, and once decisions made that you're comfortable with. So that's, you know, why one has a discussion.
Yeah.
But, you know, I'm not necessarily putting sinister motives here. I'm just saying sometimes the NDPP may feel strongly about an issue. And when the NDPP has the power to make that decision, you have to accept it when a decision is made because he or she has the power to make the decision.
Even if she doesn't include you, she or he doesn't include you. Okay, thank you.
May I continue, Madam Chair?
Sorry, yes, you may proceed. Thank you.
So, Mr. Hofmeyer, when these criticisms were highlighted in the media, the criticism of Ms. Jiba being quote unquote supine and all that, I've read you the criticisms. You didn't think anything of it.
I'm not sure I understand your question.
Okay, when the criticism was reported in the media or in the law reports, I'm not sure how often you read your law reports, or when they were highlighted in the media, what was your view on it? Did you agree with the criticism by the SCA of Ms. Jiba? Did you feel sympathy for her because you were part of a group that actually discussed this whole issue in depth before a decision was arrived at, to which you were a party?
I suppose I did have some sympathy, but I did feel that the decision of the SCA was correct.
So if you had sympathy? On what basis did you have sympathy? On the basis that, or maybe help us, on what was the basis for your sympathy of Ms. Jiba?
Just, I suppose that's a rather critical judgment had been delivered about her.
What about the fact that she did not take that decision on her own? Or let's unpack her decision. You accept that she never, yes, formally, obviously she took a decision because she was the then head of the NPA. But we know that she was in a group of very senior NPA officials, which included you. We know that the group was advised by senior counsel and a counsel, or senior and a junior. And we also know that the issue was debated in several meetings, which Advocate Kennedy talks about in his memorandum, before a decision was arrived at that you should take this neutral supine stance. Do you accept all of that?
I do accept that we had council's views on it, and that seems to, if I recall correctly, support the position we were adopting.
So would it be fair to say that where you say you had sympathy with Ms. Jiba, it was on that basis that, wow, to get sort of direct criticism of a decision that we mulled over, that we debated at length, where we got council's opinion. And yes, I may have disagreed, but at the end of the day, this is a team effort. So it's a bit hard to blame a single individual for that decision.
I think when you're the boss and you motivate for a particular decision when there are views that may not agree, you are the one in the firing line who has to take responsibility for it. And if the courts are critical of you in that decision, then you have to take it on the chin.
Is that exactly what happened to you in the other spy tapes case? Because you were intimately involved, you had to take all these criticism on the chin.
I suppose there's some analogy there.
Now, this is what Advocate Kennedy says at paragraph 51 of his memorandum. These criticisms by the SCA of Advocate Jiba overlap with those of Matopo J, which I have addressed above. Again, it is to be stressed that what was done in relation to the conduct of the matter and the preparation of Advocate Jiba's affidavit was done on the basis of careful discussion and professional legal advice, which we furnished her. She gave us instructions which accorded with that advice. Do you accept that?
I do.
In relation only to this matter for the time being, would you accept that that conduct of Ms. Jiba can't fall in the category that it doesn't make a fit and proper person to be an NDPP or an acting NDPP? If we limit ourselves to this decision.
Yeah, I think to the extent that it's part of a variety of reasons, it's relevant. But I would agree with you that I would be surprised if it's grounds for dismissal, one single decision like that.
Thank you. Now,
How are you
Madam
doing?
Chair, I'm sitting in a foreign country. Can we have a
Yes,
2 or
same.
3 minute comfort break?
Yeah. You know what? I was actually going to ask you how you are doing because you said you wanted 2 more hours and you left with about 30 minutes. So you want to have a break because you're sitting in a foreign country. Okay. I thought you'd do that when you were here too. Okay, I think you can have a 5-minute break.
You know, I don't want to be deported before Brexit.
Okay, I think you can have a 5-minute break. Can we break for 5 minutes?
Thank you.
Yes,
Thank you.
thank you.
and the Minister versus Phillips. It's reported in 2012 brackets 2 All SA 513 SCA Court of Appeal. Now, have you had an opportunity to read that judgment since we were last engaged?
Yes, Chair.
And you'll recall that that judgment concluded by confirming permanent stay of the prosecution of Mr. Phillips. You recall that?
You're breaking. Mr. Arendse, you're breaking. Let's just try to do something here. I don't know. Try again.
The Phillips judgment, the 2012 CA judgment, that judgment found that the permanent stay of the prosecution of Mr. Phillips that was ordered by Sitchwell, that was justified.
Just a minute, Mr. Arendse, you're breaking. I don't know if it is from your side or from us. We'll try to do something here. Can you just wait for a second or so? Let's try again, Mr. Arendse.
Staff, can you hear me?
We can hear you now, but let's proceed. We'll tell you if we can't.
Okay. I was referring to the Phillips 2012 SCA judgment. That judgment upholds decision by Judge Sitchwell granting Phillips a permanent stay of prosecution. Do you recall the judgment?
I do.
Now, we know that that judgment too has a number of criticisms of the manner in which Mr. Phillips was prosecuted. Do you recall some of those criticisms?
Chair, I would appreciate it if you can spell them out for me.
Unfortunately, I would have raised them either by if I had a hard copy, which I don't have. Alternatively, if I had a junior next to me to bring up the judgment. I'm not sure whether the judgment is in the Dropbox. So I can't actually read them to you.
Mr. Arendse, you don't have a junior next to you. Unfortunately, he's here in South Africa and not there.
Can Mr. Hoffman, I actually, for a change, I don't want to dwell on the criticisms in the judgment. I just wanted to ask you whether you were aware that the court was critical of the manner in which Mr. Phillips was prosecuted. What I've made a note of, and maybe you could can you look specifically at paragraphs 36, 49, 55, 56, and 59? For example, at paragraph 49, the court is critical of what it describes as systemic failures in the prosecution of the matter. At paragraph 55, the court said that it could find no fault in Judge Satchwell's reasoning. At paragraph 56, the court said that the permanent stay was justified, and the court concludes with a censure in paragraph 59. I'm not sure if you recall some of those remarks or criticisms of the court in that judgment.
Chair, I unfortunately don't have the judgment in front of me, so it would be helpful if they can be pointed out, but the criticism so far all seems to relate to the prosecution of the matter, rather than the asset forfeiture component that I was involved in.
So, did you had nothing to do with the prosecution of the matter, played no role, even as the head of AFU?
I mean, we obviously, the Joburg office of the asset forfeiture unit was dealing with the matter. So I think they were briefed and kept informed on the developments of the criminal matter, but personally I was not really involved with the criminal matter.
You weren't involved? Were you interested in the criminal matter proceeding? Wasn't it important for the AFU to ensure that there was a successful criminal prosecution?
It is, and in some cases it isn't. So against Mr. Phillips, we had used the non-conviction based asset forfeiture provisions, and we had also obtained an order in terms of the conviction-based asset forfeiture. So our eggs weren't all in one basket.
So you mean the fact that a permanent stay was granted, effectively clearing him of any criminal conduct? Are you saying that this had no effect on the restraint order that you were granted in December 2000? In other words, 12 years or so, it's about 12 years or so when the judgment was granted him a permanent stay. You say that had no effect on the restraint order granted in the year 2000?
No, obviously it had an effect on the restraint order, but I'm saying we also had a preservation order in the case. So it was not only related to the criminal case.
So what explain to us, what is the effect of the judgment that was granted in 2012 by the SCA? Didn't it mean in layperson's terms that his assets that were the subject of a restraint order granted in 2000, that all his assets had to be returned to him?
Well, not all the assets, but all the assets that were subject to the restraint order. The property of the ranch where the brothel was being run was subject to a separate freezing order under the non-conviction based asset forfeiture provisions.
And that, are you saying that that wasn't part of the SCA order?
That's correct. That's my understanding.
So those assets which were part of the restraining order of 2000, have they been returned to Mr. Phillips?
I mean, I've not been with the asset forfeiture unit for some time, so I'm not up to date on the latest developments around the case. But I know that he was raising a dispute at one stage that he wanted the assets returned subject to certain conditions only. So at the moment, I'm not aware whether all the assets have been returned or not.
But I think you were only removed, or moved rather, as head of AFU in 2015 by Mr. Abrams. Isn't that so?
That's correct.
So for some 3 years, or between 2 and 3 years after the SCA judgment, what did you do to ensure that Mr. Phillips gets his assets back, those subject to the restraint order?
As I indicated, I think we were desperate to get the assets back, but he would not accept them back except under certain conditions.
Did you take this matter to court for the court to decide on which basis they should be returned, or for the court to ascertain whether Mr. Phillips' conditions that he demanded be attached, that those were perhaps unreasonable?
Yeah, unfortunately, I just couldn't talk to the person involved in the matter to get an update of where it is today. But I know that Mr. Phillips had a series of preconditions before he would accept the assets back. So, but what's happened lately, unfortunately, I was not able to get an update since the issue was first raised yesterday.
Now, so if they haven't been returned, that means the people looking after the assets, the curators, they are still being paid for looking after these assets.
I would assume so, but I do know there was a litigation instituted last year, because I heard from Mr. Abrams about this. But I don't know at what stage the litigation is now.
No, the litigation was instituted while you were still the head of the AFU, Mr. Hofmeyer, in 2014.
Indeed,
Mr. Silver,
and we disagreed with the terms and conditions on which he wanted to have the return of his assets.
now, up until, so the state is still paying the curators for looking after Mr. Phillips' assets. Is that right?
I'm not sure what the current state of the case is, as I say, I wasn't able to get an update overnight.
Well, you can take it from me. The assets have not been returned to Mr. Phillips. It is the subject of court proceedings, and he's suing the state and the NPA. I'm not sure whether you are also a respondent, but it hasn't been returned. Now, in that event, the curators are still looking after these assets, and they are presumably getting paid by the state.
I can agree if you say presumably, but I just don't know as a fact what the current state is.
Now, the issue of the return, or the questions around when these assets were to be returned to Mr. Phillips, they were raised with you in meetings when Ms. Jiba was the acting NDPP. Do you recall them?
Indeed.
and it was resolved that action be taken. You were still the head of the AFU. Do you recall those resolutions?
The issue here is that Mr. Phillips instituted litigation to say that we cannot return it unless certain things happen. So as far as I know, it hasn't been returned, but I don't know if that is the actual state today. I've been out of the asset forfeiture unit now for, I think, 3 years or so. So I just have not been included in the developments around the case.
But let's talk about when you were the head of the AFU, because you seem not to want to take responsibility for anything, Mr. Altmaier. So in the period from the 22nd of December 2000, when a restraint order was granted, and when you left the asset forfeiture unit, or you were removed as the head of the asset forfeiture unit in 2015, the state must have spent many millions on curator fees to look after those assets. Is that right?
It is correct, but I think it is important to put it in context that overall the asset forfeiture unit, if I may say that, operates at a profit. In other words, it takes more money from criminals than it costs to run the AFU. But that's not the case in every case. And in Phillips and in some other cases, the litigation and associated cost actually became more than the money that we could realize from the confiscation or forfeiture of the assets. I think our view at the AFU is that our business is not only to generate a profit for the state. Our business is to take on criminals who are powerful, who have a lot of influence, and who have a lot of money. So in several of those cases, we've ended up spending more taking the money away from them than the cost of the case. But that was very much a view that we got from our colleagues overseas. Is the business of asset forfeiture cannot be seen as a money-making scheme for the state. It's primarily a law to deprive criminals of their property. So this is not the only case where we operated at a loss, if I may call it that. But generally, as the asset forfeiture unit, we did bring in a lot more money to the state coffers than what we cost the state. But that is not the primary purpose of our work. Was not to make money for the state. It's to deprive criminals of their property.
But Mr. Altmaier, do you accept that you can't call Mr. Phillips a criminal? Has he been found guilty in a court of law of any of the charges that were brought against him? Keeping a brothel, procuring females, and living off the proceeds of prostitution, perjury, contravening the Immigration Act. His prosecution was permanently stayed because the prosecution failed to prosecute the case and to secure conviction.
Indeed.
So he doesn't fall into that category. I think I understand. In fact, I fully agree. In fact, I've got a small confession to make even. I hope it's not a I hope it's not a
You wouldn't have been the only counsel who went there, but if that's what you're implying.
I'm talking, I know you would, some would think that, but you may recall that I also acted as counsel in one of the early skirmishes with Mr. Phillips at your request, actually.
I do recall.
So was hoping that it wasn't a conflict of interest. I was of course tempted to do an inspection in loco, but that was.
I was hoping that you wouldn't make that kind of confession.
Anyway, so Mr. Hofmeyer, we can't put Mr. Phillips in that category where you quite rightly say that we cannot allow criminals to live off the proceeds of crime, and that's the purpose of the law. But in the case of Mr. Phillips, it seems to have gone badly wrong. Do you agree with that?
I think of all the cases that we did at the asset forfeiture unit, that probably became the most heavily litigated of all the cases. And I think we literally had 20 or 30 different applications and other challenges, either to the order itself or to the conditions of the order. So it was one of the most difficult cases we've dealt with.
And it's also the case on which the most money was spent by the unit and by the NPA.
That's probably true, but I'm not sure if it's true anymore because I don't have the information about the cost of other cases since I'm not at asset forfeiture anymore.
No. We are talking about the period when you were the head of the AFU, Mr. Hofmeyer. Many millions of rands were spent on the Phillips matter. And it's now been described as fruitless and wasteful expenditure. Do you know about those allegations?
I think there was an attempt many years ago we were investigated by our accounting officer for fruitless and wasteful expenditure. I've not been informed that there's been any negative finding about that. I may not know if there is one, but I've not been informed about it.
I mentioned earlier, and I just found the minute now. There's a minute of a meeting. That was convened at the time. Where this issue of Phillips was raised both by Ms. Jiba and by Mr. Kasana.
And while you're looking for the information, just be mindful of the fact that you have exceeded the 2 hours that you asked for.
Madam Chair, I need longer than 2 hours. I'm not sure whether you want me to come to a temporary halt and allow my colleague to continue, and that I continue at some other time. But I have not. I need more time.
When you said you needed 2 hours, you didn't say you personally.
Well,
Wait a minute. You said you needed 2 hours, 2 more hours to cross-examine the witness. How long do you still need?
I think I will need another hour, ma'am.
Mr. Ramawel, would you give him that indulgence?
We finish at 7.
Is it not? I do not understand. I do not understand whether it's a request or it's a request based on the fact that you are suggesting that he has exceeded his estimated time.
He says he needs more time than what he initially thought he needed.
Yes.
That's how I understand him. And then he said 2 hours, and then you said after that you will need an hour. So if it takes more than 2 hours, it means he postpones your time. And in other words, we will have to sit later than we had envisaged, maybe until 7 o'clock or 8 o'clock. And I don't know if the witness would not, would have the stamina to sit through until 7 o'clock or 8 o'clock, because we still have re-examination to get into.
Madam Chair,
We had agreed that we would finish this cross-examination, isn't it?
yes, we did, but Madam Chair, I do not understand the switching off, because he says he needs at least an hour, and I said I need an
You
hour,
don't mind to go
an hour
later,
or more.
which means you will go later, an hour later, and you don't mind that.
I don't mind. I don't mind.
Is it okay with you? I don't know what it means for the, not only for Mr. Hofmeyer particularly, and then the recording people, we will have enough, we will be all right. No, thank you. Yeah. So you will be fine?
Madam Chair, it becomes incredibly difficult when you've had a witness who's sitting since 10 o'clock to take him back to staff at 7 o'clock at night or 6 o'clock at night that he testified a week ago.
Yeah.
I would suggest that we finish cross-examination today and we do re-examination tomorrow morning.
Yeah. I think, if we finish the cross-examination, I think it will count. And then we can re-examine tomorrow.
But Chair,
Because you see, tomorrow again, we all knew that we were not sitting and we fitted in other things. But can I ask for your cooperation and ask that we go with the cross-examination until we finish, and hopefully we will do the re-examination. But if we can't, because Mr. Hofmeyer cannot sit more than the hours that we had envisaged, then we continue with the re-examination tomorrow. Will that be fine with you? Let me ask him. Will that be fine with you, Mr. Arendse, if we continue with the re-examination tomorrow? You don't have to be there. Your partner can do that.
Madam Chair, I will ask to
Unless,
be
of
excused
course, you
tomorrow.
will be available. Yes?
Yeah, Mr. Masuku will be available and Mr. Majavu. I can't be tomorrow, Madam Chair. So if any new issues arise during re-examination, they will have to deal with it, Madam Chair.
I think they are willing and ready to do that. I'm not speaking on their behalf, but I think knowing them, they would be willing and ready to do that. So let's complete the...
Chair, can I just make the point that it has been a very long day.
It has
and
been a
very
long day.
Huge amounts of
Yeah.
detail, and
Yes.
I really would prefer not to go on for another hour or 2 hours if we are going to have to continue tomorrow anyway. But I am pretty exhausted at this stage, if I may say so.
Nasreen, how long do you anticipate your re-examination will take?
It's definitely going to take more than 2 hours. You will remember there was a range of answers Mr. Hofmeyer wanted to give in cross-examination, and the directive from the bench was, from the presiding officers, was that he must answer it in reply.
Yeah. So can we finish this cross-examination by Mr. Arendse? And then Mr. Ramawel, will you be willing to do it tomorrow?
Yes, I think that would be preferable.
Yeah.
Madam Chair, would we consider starting earlier tomorrow?
Then we can start early tomorrow because I think there's a meeting that Advocate Moroka needs to attend where she chairs it, so she has to be there. Okay. We can proceed with the cross-examination until Mr. Arendse is done for the next 30 minutes or so, and then we'll adjourn until tomorrow, and Mr. Ramawela will start. And we will determine the time, what, 9 o'clock? Is 9 o'clock a reasonable hour? Yeah, okay. Let's proceed, Mr. Arendse, for the next hour.
Thank you, Madam Chair. I'm sure you understand when I said 2 hours, it was purely an estimate. It always depends on the level of engagement with the witness. Thankfully, we're not in the...
If you can be shorter, we will appreciate. I think you also need to strategize, you know, when you do these things. Can you try to make it shorter, but we will give you up to an hour and hope that you will finish.
Thank you. Thank you. Mr. Hofmeyer, I've got a minute of a meeting dated 5 March 2014. The chairperson was Mr. Nkosana. This is an executive of 2014. And at item 5.18, there's a minute that records your briefing to Exco regarding the Phillips matter. At item B, Mr. Kasana inquired what is prohibiting the NPA to release the assets and save curator expenses. The chairperson further inquired why, since the judgment in October 2012, there was no attempt to rescind the judgment and give notice to release the assets. The CEO informed Exco that she wrote a letter to Mr. Hofmeyer regarding the matter and that the continued curator fees must be disclosed to the Auditor General as wasteful and fruitless expenditure. Advocate Magotla responded that the matter was discussed with the former acting DPP South Gauteng and the former NDPP, and State Attorney was also involved. The CEO inquired about the detail of the assets which were retained. Mr. Hofmeyer responded that it is residential properties. Then after further discussion, it was agreed that 1, notice must be given to Mr. Phillips that the assets will be released. 2, if the notice is opposed, the NPA will appoint counsel if needed to defend the nature of the release. 3, AFU must apply for the rescission of the judgment of the Court of Appeal. And 4, Exco must arrange to be briefed about the legislative mandate, policies and procedures of AFU. Now, can you recall whether you executed these resolutions taken in that meeting?
Chair, the matter was litigated by the Johannesburg office of the Asset Forfeiture Unit, and we conveyed to them the need to do it. My understanding, but it is a long time ago, is that essentially Mr. Phillips has done everything in his power to resist the return of the assets other than with serious preconditions. But if I'm expected to give more details than that, I am going to need time to find out what happened, because quite a lot of it happened after I left the Asset Forfeiture Unit, so I don't know what the state of the case is at the moment.
But again, we're talking about a period when you were the head of the NPA unit, and this was resolved in a meeting. In fact, you reported to the meeting. Yeah?
I did indeed, but perhaps I should start with making a more general observation. And that is that the asset forfeiture unit is not there to generate money for the state or to generate
I think that
profit.
observation
Yeah.
you've already made.
Yeah. So,
Are you going to repeat what you've already said?
okay, I won't repeat it,
Please.
but
Now, what I'm looking for, and maybe my colleagues have a copy there, there is a memo that was dated the 30th of June, I think, that was written to, it was from Ms. van Rensburg in her capacity as CEO, and it was addressed to Mr. Abrams, but also copied to you, dated 2015. Do you recall that memo?
I don't have a copy of the memo. I have not seen it since then. I did see it at the time.
Can I just ask, Madam Chair, whether one of my colleagues has a copy of it? I know we made hard copies of it the last time.
Mr. Majav, if you've got a copy, your colleagues say they don't have a copy, the witness doesn't have a copy.
Maybe it's an oversight on my colleague's part. We wanted to hand it up, and we were directed rather to exchange it between us so that it can be on Dropbox. I did personally give it to them, and I also gave an extra copy to Mr. Hofmeyer so that he also has an opportunity to cast his eyes on that. Was that the Phillips judgment and the other SCA judgment? So I did hand over a copy to the evidence leaders, 9 of them, and 1 to Mr. Hofmeyer. But there's an extra one just to save time.
Sorry,
Can you
it's
then do that?
J163. Mr. Arendse got the date wrong, and so we couldn't find it. But it's
29th.
J163.
Are you able to provide him with the extra
Indeed,
copy?
with your leave, Chair.
We do that. Thank you.
Oei.
You may proceed, Mr.
Yeah, my problem is that
No,
I
you're
don't have
still
a
reading it. You're still reading it. Thank you.
Sorry, can I find it on the Dropbox? What's the reference?
J163.
J163.
Yes. Folder J. One six three.
Mr. Arons, how many pages is this?
It's five pages.
Mr. Hofmeyer, are you ready?
Chair, I have just read through the memorandum. It refers to a whole range of other documents that are not attached to it. And it really is, I mean, it coincides with the period when I was soon after removed from the asset forfeiture unit. I really would find it very difficult to answer questions without being able to go back and find out what actually happened
Unless
after
the
all of
questions
this.
don't refer to those further reference documents, you might be able to answer. Let's just hear what the questions are. Yeah. Okay. I think you may proceed, Mr. Arons. If the questions relate to referenced documents, we may have to decide differently. Okay, you may proceed.
Thank you, ma'am. I think there isn't any need to go that far. I think the essence of my questions relate to the delay in finalizing this matter. It's a matter that comes on since the year 2000. It is still not resolved. It's a matter that has involved expenditure to the tune of 100 million rand that has been spent on curators' fees in this matter. It's a matter that involves fruitless and wasteful expenditure on the part of the state. And the question relates to whether or not Mr. Hofmeyer regards himself as accountable for this wasteful and fruitless expenditure, or does he, which he seemed to have foreshadowed already, is that given the nature of the work that they do in the AFU, i.e., you know, they catch more criminals, seize their assets more than they let off the hook, and in some cases, Phillips being one of them, yes, they're going to spend money, but that is all justified in the bigger scheme of things. If that is his short answer, then we can move on.
Chair, it really is just difficult. This refers to annexures that we don't have. There's subsequent developments that I don't know what happened. I mean, as far as I know, the litigation there's an attempt now, 4 or 5 years later, to try and settle the matter. But it's really difficult for me in a case that I think we probably had 20,000 pages of litigation to look at one document from a specific time, and I'm not quite sure what the point is that Mr. Arons is trying to show, but if he's saying that we should not lose any money when we take on big criminals, then I disagree with that point of view. It was, as far as I know, he's made a statement that it was declared as fruitless and wasteful expenditure. I haven't checked my records, but as far as I know, it was not. So it's just really difficult to deal with the sort of things that are picked out of one memo at a particular time and expect me several years later, when I have been excluded from the process, to answer questions, because I just don't know what else there is that I'm not aware of.
Can we take the questions one by one? And you will answer appropriately as the questions come. If you don't know, then you don't know. If the questions is based on a reference to another document, then you express your views. We take it one by one. Can we do that?
Mr. Hofmeyer, this memorandum dated 29 June 2015. You've seen that memorandum before, and it was informing the NDPP, Mr. Abrams, who had then just been appointed. Do you recall that?
Yes, I do.
And do you recall that the memorandum, and it's in bold, it's on page, I think on page 3 of the memorandum, it is requested that approval be granted, 1, to request the status report on the Phillips matter on a monthly basis from regional head office Joburg to the CEO, as well as 2, to proceed with the payment of outstanding invoices. The payments made from after judgment till date be viewed as fruitless and wasteful expenditure.
Don't give him too long statements, Mr. Arendse. Let him chew them bit by bit.
Yes, I think Mr. Hofmeyer will confirm that that was in, I'm reading from the memo. And then in regard to the, at this point, on the 15th of June, I think the
Is it the 15th or the 30th?
The payments made, can I just read from the memo? Payments made after judgment in 2012 amounted to, payments made until judgment, that's in 2012, was over 36 million rand. That's from December 2002 to judgment date, June 2012. Payments made after judgment in 2012 amounted to over 43 million. According to the CEO of the NPA, this amount is viewed as fruitless and wasteful expenditure because it is viewed as unnecessary expenditure. So payments to date was just under 80 million. You see that, Mr. Hofmeyer?
I see the amounts. As far as I'm aware, Mr. Phillips's assets were worth well over that amount. I also would like to mention that as far as I know, it was not declared as fruitless and wasteful expenditure, although that is mentioned as a proposal by the CEO. But, Chair, my difficulty is just I don't know what's happened. I was certainly not charged with fruitless and wasteful expenditure, if the council is trying to indicate that. But in the interest of fairness, it's really difficult. This case, as I said, comprises a huge volume of documents. And for me to sit and answer questions which I'm not sure how relevant they are to this inquiry, it may be relevant if I had been charged with fruitless and wasteful expenditure. I'm not quite sure why, but I wasn't charged.
Mr. Hofmeyer, isn't it so that what Mr. Arendse is trying to point out to the panel is that in this specific matter, payments were made for a period of time, and these are huge payments. I think that's really the bottom line of what he's trying to say, unless I don't understand. And I would imagine that you are able to answer that question, that it's an inordinately huge amount of money that was paid over a period of time in a matter that hasn't been resolved to date. That question you are able to answer.
I thought I did try and answer it earlier. But let's say Mr. Phillips was a high priority target for law enforcement, for the police. Because the police came to us and said, many police officers go there. the suspicion was that photographs are taken of many police officers when they engage in certain activities. Even prosecutors went there from the information we got. So for Mr. Nguka, who was the NDPP at the time,
Can I stop you?
personally
Can I
decide-
stop
yeah.
you, Mr. Hofmeyer? Let's confine ourselves to the questions that you can and the questions that you cannot answer. We've got an answer from you about the issue about payments. And you say you've already answered that question. Can Mr. Arendse then move on to the next question, if we could?
I think, Mr. Hofmeyer, if you ask why I raised these issues, you were not charged with misconduct arising out of the spy tapes matter, which we debated at length this morning. Right? We will contend that you should have been charged and that your conduct is far more serious than anything Ms. Jiba has been accused of. Because this you will appreciate is also somewhat of a disciplinary inquiry into the conduct of Ms. Jiba. And she could lose her job as a result of whatever comes out of this inquiry. I'm sure you will accept that. And you will know, as a lawyer, especially as a public interest lawyer, that an employer will be required to act consistently, uniformly, when people committing more or less the same transgressions, they must be treated equally. And that is an
No,
important
Mr. Arendse,
consideration.
can you just ask him or put statements to him shorter than that so that he can answer them in those chunks? Don't try to avoid to make lengthy statements mixed with questions, then he won't know how to answer them. Just give him an
Madam Chair, with
opportunity to
respect-
answer the questions the way you want
No.
him to answer them by putting either statements or questions one at a time. We asked him to apply his mind to singular questions. Can we just try to assist him, because he's also tired, to do that? And then you can get the answers that you're looking for.
We've all been sitting here for a long time, and we've all been sitting through Mr. Hofmeyer. I think this is the third day. It actually is now becoming like a cricket test. We're moving towards day 5 of this test.
Mr.
So
Arendse, can you just ask Mr. Hofmeyer shorter questions? And can you just put shorter statements to him so that he is able to give you the answer that you are looking for?
Madam Chair,
Can you kindly assist us?
He's already answered one question. He said,
Move
look,
on to the next one.
One, as far as he was concerned, the money that has been spent on the Phillips case has not been declared a fruitless and wasteful expenditure. 2, he says, even if it was, I've not been charged with it. And 3, I'm making a statement to him which is entirely relevant to my client's situation.
That is not the issue. All that we're asking you to do is to put statements, shorter statements to Mr. Hofmeyer so that he can answer you. Put shorter questions to him so that he can answer you. If you give him long statements, he is not going, this time of day, of hour, he is not going to give you the answers that you are looking for, so that we avoid repeating questions because he is not getting where you want him to go to. Can you just kindly give consideration to the fact that it is this hour of the day and ask shorter questions, make shorter statements? You will get the answer. And don't repeat it, yes. Please, just assist us.
Mr. Hofmeyer, you'll see that the letter of the CEO in the very last paragraph also contains or request from the NDP an instruction that you must close all overdraft facilities in terms of the curator accounts and to find an alternative way of dealing with the payment of curator accounts. Did you carry out that instruction?
Chair, I did not carry out the instruction in full at the time because we had a considerable amount of overdraft facilities, and the motivation for that is that the NPA did not have enough money in its budget, so that it makes sense to, if we are going to get in many millions of rands later, it made sense to fund it from what we call the overdraft facility until we actually get the money in because of the budget. You'll remember that there were huge budget crises in South Africa during the 2008 financial collapse and afterwards, where our budgets were cut. So the overdraft facility wasn't controversial. It was agreed by National Treasury. It was agreed by the Department of Justice. So I'm not quite sure what the relevance is of the questions about the overdraft facility.
The question was that contained in the memo, Mr. Hofmeyer. An instruction was given to close all overdraft facilities. And you're saying that it wasn't, and you've given reasons why it wasn't. That was the question. Now these overdraft facilities, you say there was an agreement. Where is this agreement with Treasury? Can you produce the written Treasury instruction? Because we know, otherwise we're going to waste more time, that you were a signatory on these overdraft facility agreements with some of the banks. On what authority, on whose authority did you sign these agreements? And was there a Treasury instruction that you may do so?
Chair, I think we complied with all the requirements at the time. We got the Treasury approval. Out of this memo, I think it's sufficient to say that whatever was recommended here as action against me was not taken. And it was not taken by Mr. Abrams, who really wanted to get me out of the NPA. He even offered me other jobs to get me out of the NPA. So all I can surmise from the limited documentation that's been put in front of me is that this issue was not pursued further, but I would welcome the opportunity to go back and find out what happened about it afterwards. Because I was removed from the AFU quite soon after this, so I just don't know what the status of overdraft facilities and other things are anymore, and I don't know how to give evidence on that.
You'll see at the foot of the...
Let me just add, that the NPA had a process in relation to the audits by the Auditor General and so on. That disciplinary action is taken against officials who did not follow the necessary financial prescripts. In 2010, when the PFMAs first started biting, I think dozens of us got warnings about this and that and the other thing. But in relation to this payment, this case, and despite an NDPP that wanted to get me out, no action was taken against me about this. So my only conclusion can be is that it was investigated by the relevant people and they decided not to take action.
Why is that your only conclusion? Because we see here a note, a handwritten note, which appears to be that of Mr. Abrams, at the bottom, at the foot of the document. Dear Dr. Amahiti SC, 1, the payment viewed as fruitless and wasteful expenditure must be investigated, particularly in line with the prescripts of the PFMA. 2, the entire matter must be audited. This must be brought to the attention of the Auditor General. If necessary, independent auditors must be approved. 3, persons responsible. In this case, any irregularities have been, identified, must be held accountable departmentally and criminally. And kindly assist herewith. Now, can I ask you, those 3 steps that Mr. Abrams wanted Dr. Ramayeti to implement, is there anything wrong or unreasonable with having required him to take those steps?
Given that the steps were not taken, I think those who were in charge of taking those steps came to the conclusion that there is no valid grounds for instituting those steps.
I'm asking you
Mr. Abrams was certainly not
a simple question.
Yeah.
I'm asking you a question. Do you think on the face of those 3 steps, were they unreasonable or unjustified in asking for those steps to be taken?
I do think it was unreasonable because it was not supported by the facts, and that's why no investigation and no action was taken against me afterwards.
But the facts is summarized in this memorandum. All this money that was spent on a case after many years that was successfully stayed on the part of the accused.
There is a process to determine whether it's not sufficient for somebody to write a statement that it's fruitless and wasteful expenditure. There has to be an investigation. The facts have to be looked at. Many people have been charged in the NPA for fruitless and wasteful expenditure. But clearly, all I can conclude is that there was not a case to take up against me because I was not charged.
After Mr. Abrams had given those instructions, do you know if those instructions were followed up?
To the extent that the question, any question I can answer is, was I charged? I was not charged.
I'm just trying to get clarity here. Were the instructions followed up? Do you know?
I don't know,
You don't
but
know.
can go and try and find out if the Commission wants to hear.
No. I just needed to know were those followed. Do you know if they were followed up? Were you ever charged with?
No.
Thank you.
Can I ask, Madam Chair, for the evidence leaders to
Yes, Mr.
request from Dr. Ramayeti whether these instructions of the NDPP were carried out, and if so, what the outcome was, and if not, why didn't he carry them out?
Can you hear
Madam
from
Chair, I'm battling to figure out whether we're investigating Mr. Hofmeyer or whether we're investigating Advocate Jiban Mkhwebi. And maybe if that is clarified, then you can tell me whether it falls within our terms of reference. Unless you rule we must do that, I'm very far from trying to figure out what's the relevance here.
Mr. Hofmeyer says he doesn't know if those instructions were ever followed up. To this day, he has not yet been charged. So it means, therefore, that nothing became of those instructions.
I think that's the only conclusion that is.
Madam Chair, can I also add, the memo is written by Karen van Rensburg to Sean Abrams. She testified. If there was anything about this that needed to be asked, there was every opportunity to ask Ms. van Rensburg about it.
Those issues during re-examination.
I think, and correct me, Mr. Arendse, if I'm wrong, the issue that you want to raise and that you want to address the panel on at an appropriate time is a question of consistency. And the fact that on your client's version, there wasn't any consistency. If there was, Mr. Hofmeyer would have been charged. I think that's the relevance of what you're submitting to us. Therefore, I would imagine if you are minded to do so, would be either to recall Mr. Ramaite or to recall the CEO. I do not think it serves any purpose to ask somebody who's supposed to have been charged, why were you not charged or were you charged? It would be much easier for you to recall those witnesses if the evidence leader doesn't find the relevance.
The relevance of this matter is simply this. Mr. Hofmeyer has accused Mr. Abrams of removing him from the asset forfeiture unit. On the face of this memo, there appear to be serious questions that demand answers. The NDPP demanded answers, and
can I interrupt you?
Can
I interrupt you, Mr. Arendse? I don't dispute that there may be an issue of relevance. I'm not disputing that. I'm not finding that the evidence leader's assertion that she doesn't find relevance is the correct one. I'm not doing that. All that I'm saying to you is that it would seem that you're going to raise the issue of relevance and consistency. And I accept that and I agree with you. All I was trying to say is the process of getting there might just be a recall of one or two witnesses. That's all I was saying to you. I'm not saying it's not relevant.
Because you might be asking the questions from the wrong person.
And I had asked, for the sake of progress, that the evidence leaders, and I can't see why this task should not fall within the ambit of their duties, is to request Dr. Ramatihiti whether one is aware. He may not even be aware of this memo. He may not have even received it. And if he did get those instructions, what happened to them? This is also a memo that I received after Ms. van Rensburg and well after Dr. Ramayiti gave evidence. Dr. Ramayiti was a first witness. And he was a context witness. He testified on how the NPA works and so on. So yes, I didn't have the memo. If I did, I would ask him, or I would have asked my colleagues to ask him questions.
I think that might be a better way of proceeding with this instead of asking Mr. Hofmeyer questions that he can't answer. We will ask the evidence leaders to do that. Thank you. You may proceed.
Because if there was an investigation into Mr. Hofmeyer's conduct, which he is clearly not aware of, it could also be that that was the basis of his removal as the head of the AFU. So for him to say the only conclusion is that there was an investigation and it was found that there was no basis to further pursue the investigation. That's what I'm getting at. That is not the only conclusion that is available to us on the evidence.
And we understand the context of your questions, Mr.
Thank you.
Arendse. What we are asking
I just want to move on to
is that you ask the correct person those questions, because Mr. Hofmeyer cannot answer them. Okay, thank you. You can proceed.
May I move on to another topic? Mr. Hofmeyer, you tendered an affidavit in the DA matter in the Western Cape High Court case number 17782 of 15, which came before Mr. Justice Delamo. That case was a case of the DA versus the President and others, with the JIBA as the fourth respondent and the GCP as the fifth respondent. Do you recall that?
I do.
Now, in that matter, the DA sought leave in terms of Rule 65E to introduce an affidavit from you, Mr. Hofmeyer, and also from Mr. Kasana. You recall that?
I do.
Now, in motivating for the admissibility of those affidavits, Mr. James Self said that it was vital for the proper determination of the matter and is of significant public interest, and that the DA was duty-bound to bring it to the court's attention. I'm not sure whether you read Mr. Self's affidavit or whether you are familiar with what he said in that affidavit.
No, I didn't read it.
Mr. Hofmeyer, do you still have water there? Oh, okay, thank you.
I've run
can
out of water,
proceed.
Madam Chair.
I expect you to have water
We can
because you
courier
provide
to
for
him.
yourself. Okay, thank you.
Now, this aspect is at the, I've made a note, Dropbox 6.4.14.1. I'm not sure which item 6. Now,
Which folder in the Dropbox?
it's I'm not sure. It would be on, it's the court records.
It's folder G. It's number 6. Let me just, sorry, number 6 of it. And it's 6.4 of the documents of that case.
Yeah. 6.4.14.1. Yeah, it's the Rule 65 application. Now,
Okay, sorry, we don't seem to have that on our Dropbox.
Folder G, 6.4 of the document of the case.
now, may I proceed, Madam Chair?
I think you may, Mr. Hofmeyer.
Thank you. Now, Mr. Hofmeyer, you will recall that you and your legal representatives had independently prepared the affidavit, and that you had, in fact, tendered it to both or to all the parties in the case. Can you remember that?
That's correct.
Now, for the DA, they said that the reason why they elected to adopt your affidavit was primarily to respond to Sean Abrams' allegations that there was a vendetta against Ms. Jiba. I'm not sure whether you recall that or whether you are party to that statement made by the DA.
I certainly wasn't a party to the statement, and I don't recall the statement being made.
Well, it's on the record. It's at paragraphs 13 to 25 of his affidavit, founding affidavit. But more importantly, Mr. Hofmeyer, you annexed to your affidavit an affidavit by one Terence John Joubert. You remember that?
I do.
Why did you attach that affidavit to your affidavit?
I attached a number of documents to my affidavit. I would have to go back and check why I attached those particular documents, other than a general statement that I considered them
Can
to
you
be
try
relevant.
to speak up?
Sorry.
Try. I know you're tired now. Yes.
I did the affidavit in conjunction with public interest attorney at Weber Wenzel, so I did take legal advice on what I should put in and should not put in.
Did you or your lawyers, did you check the veracity or confirm the veracity of Mr. Joubert's affidavit before you put it in or attached it to yours?
I did not check on the veracity of the affidavit, partly because I was in a meeting with a person, let me say Mr. Molele from the Asset Forfeiture Unit, when Mr. Joubert phoned him with this information. And so I heard the discussion, I heard the issues, and I think it was not from my instigation, but I think the affidavit got drafted after his discussion with Mr. Molele. That's a bit of supposition. I can try and verify the facts, but that's my understanding of what happened. I think Mr. Joubert also did send the affidavit to the then national director at the time.
Now, do you recall that subsequently Mr. Joubert had disavowed very strongly any association or knowledge of this affidavit? In fact, he claimed that the affidavit was a fraud. Are you aware of that?
I think I only saw that when I went through the documents for this inquiry. I was not aware of that earlier.
So, Mr. Hofmeyer, you were party to a fraud, attaching a fraudulent document to your affidavit.
I had no reason to know or suspect that it was a fraud. Nobody had said that to me. Mr. Joubert hadn't said it to me.
But Mr. Hofmeyer, as someone, I would be surprised. This affidavit was part of court proceedings in 2016, is that right?
Which court proceedings are you talking about?
The case that came before Mr. Justice Delamo.
That's correct.
Now, as someone who no doubt follows the media avidly, you're always referring to the media, you would have been aware of a report which appeared in the City Press on the 22nd of June 2014. That is some 2 years before you decided to attach Mr. Joubert's affidavit to yours. Now this City Press article is attached as NJ5. It is attached to Ms. Jiba's answering affidavit in the Rule 65 application. I'm not sure, Madam Chair, whether someone can call it up, the City Press article.
What's the date of the article, please?
Sorry, I can't hear that, Madam Chair.
I just said the date of the article. They're still looking for the article. I just wanted the date.
It's marked it's NJ5. The date of the article is 22 June 2014. And it's an article that's written by Jacques Pau and Charles Duplessis of the City Press.
They're trying to recall it.
The Dropbox expert, Mr. Masuku, will help us.
It's at 6.4.14.3.
We don't have the document on
Hold
our...
on, they're looking for it.
They're looking for it, Mr. Hoffman.
Mr. Nan? Mr. Masuku, have you got it? NJ5.
Is it not in folder G, or is it in folder G?
No,
Try folder G. Folder G.
For the purpose of time, can you give yours to Mr. Hoffman?
Mr. Hoffman, while people are looking for this document, were you not aware of this City Press report?
No, I was not aware. It's the first time I hear about it. I heard about it in the last few days in the preparation for this hearing, but I hadn't heard about that before.
Now, in this press report, it says that the State Security Agency is investigating an alleged plot to oust prosecution's boss, Nkolisi Kasana, but an affidavit it's using in the probe may be a fake. The document forms the basis of an investigation that the SSA is conducting into the existence of the plot. City Press understands that Kasana himself gave the agency a copy of the affidavit a bitter feud in the NPA with Kasana in one corner and former acting head Mokgoro Jiba in the other took a new turn last week. The affidavit obtained by City Press was allegedly deposed to by senior NPA official Terence Joubert and signed on 25 November last year. The document was sent to Kasana's private and NPA email address from Joubert's official NPA address on the same day. Kasana had only been in the job since August 2013. Joubert, however, claims this email path must have been forged. It only reached the SSA earlier this week, months after the deposition. Late on Friday, Joubert, the head of NPA Security and Risk Management in KwaZulu-Natal, told City Press that the affidavit was a fake and that he didn't depose to it. The affidavit states that Jiba asked a Hawks colonel to wage a dirty tricks war campaign against Kasana. It also says Jiba wanted to embarrass him, force his resignation, and be reappointed to lead the NPA. Joubert said that nobody had contacted him about the document and said it was strange that Kasana did not contact him to verify its veracity. Kasana declined to comment yesterday. So your evidence is, Mr. Hofmeyer, that you were not aware of this newspaper report.
That's correct.
Now, when you decided to attach, this very affidavit, which a newspaper report by prominent journalists like Jacques Pau and Charles Duplessis had already published in the City Press on 22 June 2014, you nonetheless, in the face of that, decided to attach this affidavit to your affidavit.
But he says he didn't know.
And you,
of
and no, I asked, he claims he didn't know. I asked whether you verified, what steps did you take to verify the authenticity of this affidavit? You also submitted this affidavit together with Mr. Kasana at the same time to the DA.
I would need to verify it, but I was in the room with Mr. Molele when he was speaking to Joubert about this affidavit, about what he knows about this. In my understanding, it was not all in English, so I didn't understand it fully, but my understanding from Mr. Molele was that was what Joubert was conveying to him. So I had no reason to doubt that when he did make the affidavit that he was telling the truth. Whatever may have changed his mind afterwards, I'm not sure.
Well, let's see what Mr. Joubert says. The affidavit is marked NJ6. And I read from paragraph 3. I wish to state that I dispute
we don't have
the affidavit that Advocate Billy
Just wait a bit, Mr. Arendse. They want to show Mr. Hofmeyer the affidavit. Do you have it, Mr. Hofmeyer? Paragraph 3. You may proceed, Mr. Arendse.
Thank you, ma'am. The affidavit by Mr. Joubert at paragraph 3, he says, I wish to state that I dispute the affidavit that Advocate Billy Hofmeyer submitted and is referring to. My reasons are as follows. On or about 22 June 2014, I was contacted by a certain journalist who told me that he was in possession of an affidavit I had attested to and wanted to confirm the content of the said affidavit. I requested a copy of the said affidavit and he emailed a copy to me. I perused the affidavit and saw that my details were contained in the document as well as my signature, which closely resembled mine. I read the contents of the affidavit and did not recognize any of the information contained therein. I did not associate myself with any of the information contained in the affidavit, and it was clear to me that I had not compiled the affidavit. I had absolutely no knowledge of writing anything contained in it. I suspect that my computer was accessed and my information was used to compile this document without my knowledge. An investigation was instituted to establish the authenticity of the said disputed affidavit. I have not been informed of the outcome of the investigation. I am rather shocked and surprised to see that the said affidavit is being used during court procedures when an investigation into its authenticity is still underway. I also take offense to the fact that I'm being used to fight the personal battles of Advocate Hofmeyr against the National Prosecuting Authority. I deny any knowledge of the alleged instruction from anybody, including Advocate Jiba, for me to investigate anybody outside the scope of my duties. The allegations contained in the affidavit are, in my opinion, all fabricated. That affidavit was made in February 2016. Mr. Hofmeyr, do you see that?
I do.
What was the purpose of you attaching the fraudulent document to your affidavit, Mr. Hofmeyr? What did you seek to achieve?
I resent you making those insinuations, which I've already made clear that I've never seen this affidavit before. On what basis do you accuse me of using a fraudulent affidavit?
Aside from it being you now know as a fact, it was a fraudulent affidavit. I'm asking you, for what purpose did you attach Mr. Joubert's affidavit in the first place, which he now says is a fraudulent document?
I would encourage the inquiry to get a handwriting expert and check whether it was indeed Mr. Joubert's affidavit or not.
He has said under oath, Mr. Hofmeyr.
He's given contradictory versions under oath so far.
Can I just intervene here? Mr. Hofmeyr, the question is, what was the purpose of attaching the affidavit to your statement at the time? To your affidavit at the time? And then we can go further. We can go forward.
The purpose, on advice of my attorney at the time, was to bring issues that were relevant to the fitness of Advocate Jiba to the attention of the court in Cape Town that was hearing the matter.
I think you can proceed now, Mr. Arendse.
So the purpose was to discredit Ms. Jiba and to portray her as someone who has it in for Mr. Kasana and that wants to remove him from his position. That was the purpose. That must have been the purpose.
I think we didn't need the affidavit to know that that was what was happening in the organization at the time, but it did provide more concrete evidence than what we had heard from a variety of other people.
So the purpose was indeed to discredit Ms. Jiba.
The purpose was to bring facts to the attention of the court in a hearing that was where it was relevant.
So if it now emerges that those facts were indeed fabricated and false, what do you say to that now?
As I said, before I answer the question, I would like the Commission to get a handwriting expert and see if those the affidavits were false and fabricated before we proceed on that assumption.
Mr. Hofmeyer, we've been delayed and we've put under tremendous pressure to finalize your cross-examination when the future of my client is at stake. When this is another opportunity that you're using, you want another investigation, you want another handwriting expert. These are matters that has been in the public domain since 2016.
Mr. Hoffman,
So we must have another delay for a handwriting expert to look at something that you were aware of. You were party to that case. You deposed to an affidavit.
I was not party to the case. I was not briefed on what happened in the case. I didn't know what evidence was led or not led in the case. I saw a judgment at the end, sometime later after it came out.
Mr. Hofmeyer, this is classic Hofmeyer where you avoid answering directly, you obfuscate, you obstruct, and you look for ways out of a situation when the shoe pinches. This is another example. Your evidence in this hearing cannot be trusted.
Mr. Hofmeyer, I haven't heard you say it. Are you saying that affidavit, Mr. Joubert's affidavit, is not what was said to be a fake affidavit? Is that the assertion that you make?
I've seen no evidence other than what was put to me today that he disowned or described the affidavit as a fake.
And you don't believe that it is fake, and that is why you want an expert to verify the signature.
Indeed, and we can also call Advocate Molele, who, as I said, sat in when Mr. Joubert phoned him about this, and ask him if that was indeed what Mr. Joubert was saying. Because Mr. Molele told me afterwards what Mr. Joubert was saying, as well as, because my grasp of Zulu is somewhat elementary, and that was, I think, what was the language being used.
You may proceed, Mr.
Madam Chair,
Arendse.
this is why
Proceed.
Madam Chair,
Yeah.
I started by pointing out that there was already a newspaper article in 2014 where Mr. Joubert had denied any knowledge of this affidavit. So that information was in the public domain in 2014.
And he
It is
doesn't
not that
know
Mr.
about it. He doesn't know about it.
He doesn't know about it, and we will contend that it's highly unlikely that Mr. Hofmeyer did not know about it, given his avid readership of the media and his invocation of the media all the time. That here are two prominent journalists. Shalpo wrote a book that I think most South Africans read about our former president, and he says he was not aware of this newspaper article in 2014.
Mr. Arendse, you will argue the point. You will argue, I mean, you're entitled to argue that point. That is highly unlikely. The witness has given you his answers. It is what it is.
Can you proceed?
In your affidavit at paragraph 36, you refer to the statement by Terence Joubert, a senior employee of the Security and Risk Department. In the affidavit, Mr. Joubert tells a story of how he and others had done investigations at the instance of Ms. Jiba with a view to bring about Mr. Kasana's removal from office. He indicates that they had done the same previously in respect of Mr. Gumede, who who had earlier been mooted as a candidate for the office of NDPP following the FUL application to compel the President to appoint a permanent NDPP in place of Ms. Jiba, who had been acting for a considerable period. A recording of the conversation to which he refers is available. It suggests to me that there is a systematic pattern of protecting Ms. Jiba and others improperly, not just in this case, but in others as well. It suggests that he has chosen to align himself with their agenda. While she was acting NDPP, Ms. Jiba openly boasted about a close relationship with the then Minister of Justice and how she could persuade him to do whatever is needed for the NPA. The attempts by Ms. Jiba to engage in activities that are in support of political groupings is not new. Now, Mr. Hofmeyr, these are the very kinds of reckless, unsubstantiated statements that you were accused, or rather that the NPA, Mr. Justice Napster, found that you have a tendency to make in your affidavits, and this is another one of them. You question the relevance of the spy tapes judgment. This summarizes your character, that you make these allegations without any factual basis. Now we have a situation where you attach an affidavit of a person, and the person comes along and says, sorry, that's not me. The allegations in the affidavit are false.
You want a response?
Sorry, I'm not sure if we've lost Mr. Arends or not.
No. I think he's waiting for your response, Mr. Hofmeyr.
Chair, as I indicated in relation to the Uber affidavit, nobody has ever approached me or come, if it has been in the public domain, nobody's ever come to me to say, why did you use this affidavit in other litigation? So I just can't take the matter forward. This is the first time I hear that allegation. But I would suggest that perhaps Mr. Molele should be called to come and testify on this issue, because I was with him sitting in our boardroom while he was talking to Mr. Uber before the affidavit was written.
Your answer is you were not aware of the affidavit. That's your answer.
Of his recanting affidavit, if I might put it that way, yeah.
Now, Mr. Hofmeyr, I recall you not so long ago saying that in your preparation for this matter, it was then for the first time that you saw the affidavit. I think it was drawn to your attention by the evidence leaders. Is that right?
It's not, as far as I know, in the documents that we got, but I may have overlooked it if I got it in a bundle of documents. Perhaps.
Maybe if we can put that into context, it was raised with us by advocates Fergus and Masuku that there were documents missing in relation to this matter in the Western Cape High Court. Advocate Fergus then furnished us with those documents via email, and I put it onto Dropbox. We didn't have those documents beforehand. So Advocate Hofmeyr was not provided with those documents by us.
Is that right? We all have the documents except Mr. Hofmeyr. Okay. Mr. Machavu?
If I may just interject, I can confirm what Ms. Bauer is saying. It's my office that actually forwarded the documents to her so that they should be put on Dropbox. Why that was not given to such a crucial witness, we don't know.
Bauer, that Mr. Hofmeyer says he only discovered this recanting affidavit when he was consulting with you, or did I hear incorrectly?
He said when he was preparing for this hearing. So I don't know, by himself with his legal assistant, or
Maybe he can clarify.
yeah, maybe you should clarify when exactly you discovered this affidavit.
Chair,
When
I
you
may
were
have
preparing.
missed it in many documents sent to me, but I did not know about this affidavit till it was put to me now.
Discuss it with Ms. Bauer.
Not
don't-
as far as I
okay.
recall.
Okay, thank you, Mr. Hofmeyer. Mr. Arendse, you may proceed.
Madam Chair, are we going to proceed until 6 o'clock your time?
You are, you are over your time with 1 hour, 10 minutes, over your time. I think you will. You will
The
be well
estimate,
advised.
I'm over my estimated time, Madam Chair.
You overestimated, I think so too, so you can.
No,
finish it.
I underestimated, but I'm over my estimate.
I think you're also tired, Mr. Arendse. You're just as tired, but you need to finish. And can you kindly try to wrap up? There's only one witness who has to go through all of these processes. So can you kindly wrap up so that we can proceed
Madam Chair,
to Mr.
I would
Ramawena.
request that if we are going to proceed tomorrow morning, then I would request a further hour tomorrow morning. If we can make an early start.
We did this today because we knew that you were not available after today. Wasn't that the case?
It's still the case, my lady. And if we start at 9 o'clock tomorrow morning, your time, it is 7 o'clock where I am. So I'm taking time that is really my own personal time. But I'm here for another purpose and another matter. But
No,
I really can't be rushed into matters of importance to my client.
Yeah, certainly. But there are also other considerations. Now, I'm weary of asking you how much time you will need tomorrow.
No, not tomorrow.
I mean, tonight, how much more time you need? Because I know that there is a likelihood that you may not stick to that time. It is possible, therefore, for all of us to sit until 10 o'clock this evening. But I'm going to do it anyway, at the risk of doing it without any particular purpose that it will serve. How long do you think you're going to be? And I'm not rushing you. We have to contextualize what we're doing. How much more time do you think you need?
I will need at least another hour and a half, Madam Chair.
Otherwise, we might have to postpone this to tomorrow because I'm looking at
Yes.
the witness. I'm looking at the witness. Yeah, oh yeah, you can.
In cricket, there's a test that was called the timeless test. Before they had the 5-day rule, they could just play until they finish.
But I did have maximum hours per day.
One of the panel, members of the panel, cannot make it until a certain time tomorrow morning. We have time limits for tomorrow morning. And we have to sit only in the morning and not beyond, what? Yeah, not beyond 12 o'clock. If we will proceed tomorrow, we have to start early and we'll have to finish early. Yeah, let's just proceed with Mr. Arendse and ask him to kindly complete his line of questioning now with what he's busy with. Then we can proceed tomorrow morning, as early as possible. Can say. We will sit until 6. We will adjourn at 6 o'clock. Okay?
Thank you, Madam.
Whatever we can't do today, we'll have to wait for tomorrow. You may then proceed, Mr. Arendse.
I'm just looking to find my clients. Perhaps, Mr. Hofmeyr, are you telling this inquiry that notwithstanding that you had on your own with your lawyers tendered your affidavit to the parties in this litigation and that you were not interested in the outcome of this case?
I tendered the affidavit with Mr. Nlasana because we thought it was relevant to the case. And to deal with certain allegations that were made against us in the papers.
And you want us to believe that you were not interested in the outcome of what you and Mr. Nkosana were tendering to the court as being relevant?
Obviously, I had some interest in the outcome of the case, but my major motivation was to put the record straight about my own reputation and integrity.
But we also know now, certainly from your viewpoint, that not only did you put the record straight, but a skewed record was put in front of the court because Mr. Joubert's affidavit turns out to be a fraud. That is what we now know.
I think it remains to be determined whether his affidavit was a fraud.
But Mr. Hofmeyr, it's been determined by a court of law. The court dismissed the application by the DA to have these affidavits admitted. Are you again telling us that you were not aware that that application was dismissed by the court?
Was it dismissed on the basis that the affidavit is fraudulent?
No, it was dismissed on the
You
grounds
don't
that
put
it
a
was not.
proposition like that to the witness, Mr. Arendse.
No, it wasn't dismissed because it was fraudulent.
But you've just...
The attempt to introduce the affidavits of Mr. Nkosana and Mr. Hofmeyr by the DA, that application was dismissed.
But for different reasons, not because
Because
the
it was because it was inadmissible.
Is that not different?
My understanding is the court didn't make a finding about the veracity of Mr. Joubert's affidavits. Am I mistaken?
Oh, now you know. Now you have an understanding. Where do you get that from? Earlier you knew nothing about the matter.
But
you
we
were
are
disinterested.
we are traversing the document right now. We all now learn of this document. He's trying to answer your question.
The answer for the record by Ms. Jiba is in her affidavit at 6.4.14.3.
Chair, we don't have that document.
I assume you're going to ask questions based on the document, Mr. Arunsa? You're going to ask questions?
I don't know, Mr. Hofmeyer doesn't seem to, he either doesn't have answers to these questions, or he will simply say, I don't know because I wasn't the party to the litigation when it suits him.
Are you going to ask questions based on the document?
Then refers to another investigation.
Because then we want to provide Mr. Hofmeyer with the document. Are you going to ask questions on that document?
I don't know, Madam Chair, because when I put things to him and we want to make progress, he will take us off onto another tangent,
But
and I may well answer.
Are you going to put issues to him so that we can make the document, we can provide him with the document?
I don't know whose responsibility is it to make this document available to Mr. Hofmeyer.
We will make it available.
So Madam Chair, can I just ask for a quick comfort break?
We have, you need a comfort break?
I don't know, Mr. Hofmeyer wants to quickly peruse this document.
Okay, I think you may have it. 5 minutes?
Thank you, Madam Chair.
Thank you.
Chair, if I may say something, I'm not at the end of the affidavit yet, but I'm on page 22.
Can you? Yeah.
I really would reiterate my request that I have a very long day.
No.
And in fairness, I need to be able to look at this affidavit properly.
Let's come back to it. Let's have a break, and then you might feel better when you come back. And we'll see what to do.